Today we will be looking at breach of contract and the doctrine of frustration. First, let's look at the actions a party can bring for breach of contract. Where a party fails to respect a contractual obligation, there are a number of possibilities. First, a party can seek damages by bringing an action in common law. There are different types of damages available under the common law for non-performance. For example, there are compensatory damages, whereby a person receives compensation in the amount necessary to put them in the position they would have been in had the contract been performed. There are also reliance loss damages, whereby a party is compensated for the investment they reasonably made in relying on the other party's non-performed promise. Alternatively, a party can request a remedy in equity. If a solution in damages is not appropriate, a party can request the court to exercise their discretionary power and to give a solution in equity. As seen when reading Chapter 3 in Volume 1, equity provides for a number of different solutions such as specific performance, injunctions, or rescission. But perhaps the best remedy for breach of contract is to provide for the event itself in the contract. Frequently, the parties to a contract will themselves provide for a remedy in cases of non-performance. For example, the contract might contain a release and waiver of liability clause. Under such a clause, a party gives up its right to sue the other party in the event of their suffering loss linked to the performance of the agreement. Alternatively, the parties might agree to establish in advance the amount of damages that will become payable in the event of a specific case of non-performance by one of the parties to the agreement. This can be done by way of a liquidated damages clause, also referred to as an LDC clause. Or the parties might exclude liability for certain cases of non-performance of a contractual duty. This is done by way of an exemption of liability clause. Finally, the parties might provide for non-performance of the duties established by contract where the performance becomes too difficult or impossible. Such a situation can be dealt with by the parties through the inclusion of a clause providing for recognition of force majeure in certain cases, or alternatively by including a hardship clause in the contract. As we have seen, even if the parties do not put in place such clauses, the common law courts may nonetheless be willing to consider the contract frustrated. The common law courts may sometimes be willing to apply the doctrine of frustration, where a party can show that the event was not provided for and dealt with in the contract between the parties by way of a hardship clause, that the frustration was not self-induced. If, for example, the event results from the negligence of one of the parties, then it will not be considered a case of frustration. Also, it is necessary to show that the frustrating event goes to the very root of the contract. So what are the differences between the doctrine of frustration and force majeure? Although similar, the two notions of frustration and force majeure are not the same. Indeed, to a certain extent, they are fundamentally different. Under the doctrine of frustration, a party will no longer be liable for performance if the performance becomes too onerous, impractical, or impossible, either objectively, but also subjectively, that is, from the point of view of the parties. The underlying rationale behind the application of the doctrine of frustration is that the character of performance for the parties has changed radically, justifying subsequent non-performance as the contract is no longer the same. Under the notion of force majeure, a party will no longer be liable for performance where the performance is objectively no longer possible. Thus, Force majeure is centered on an event and whether the event renders performance impossible. Frustration, on the other hand, is not measured by reference to the event, but also takes into consideration the party's appreciation of the event. As a result, the doctrine of frustration applies to events where the nature of performance as anticipated by the parties has changed, even though actual performance in accordance with the terms of the contract remains possible. There are other differences that also exist between frustration and force majeure. For example, frustration when operable will normally bring a contract between the parties to an immediate end. To the contrary, an event of force majeure may either terminate or suspend the agreement between the parties, depending on the nature of the supervening event and, in particular, its longevity. Also, under common law case law, no rights or duties are deemed to exist after the frustrating event has occurred. The transaction is said to be frozen in time, and thus, for example, money transferred prior to the frustrating event does not have to be returned to the other contracting party. And finally, if the event has previously occurred, it is difficult to claim force majeure, as it only applies to unforeseeable events. However, in the case of frustration, the fact that the event has already occurred will not necessarily prevent the courts from giving relief under this heading. Foreseeability is clearly important as regards the application of the doctrine of frustration, and the more foreseeable an event, obviously, the more unlikely it to be considered a case of frustration. However, it is not so much the foreseeability of the event that is important under frustration, but whether the more onerous nature of the performance was foreseeable by the parties as a result. Under the doctrine of force majeure, it is the event and its unforeseeable character that triggers the application of force majeure. We hope you enjoyed this discussion of breach of contract and frustration.